Diminished responsibility is one of 3 special defenses which exist solely for the offense of murder. It is contained in the Homicide Act 1957 as modified by the Coroners and Justice Act 2009. Where the defense of diminished responsibility is successfully pleaded, it has the effect of reducing a murder conviction to manslaughter. The 3 special defenses of diminished responsibility, loss of control and suicide pact differ from general defenses in that they are only applicable to murder. They do not apply to any other crimes. Also, the effect is to reduce criminal liability rather than to absolve the defendant from liability completely. Diminished responsibility is set out in Section 2 of the Homicide Act 1957 as amended by Section 52 of the Coroners and Justice Act 2009. To rely on the defense, the defendant must be able to demonstrate the following. 1. An abnormality of their mental functioning caused by a recognized medical condition. 2. Which provides an explanation for the defendant's acts or omissions in being party to the killing. 3. Which substantially impaired their mental ability. 1. Abnormality of the mental functioning caused by a recognized medical condition. The question of whether the defendant is suffering from an abnormality of the mental functioning is for the jury to decide after hearing medical evidence. The jury are not bound to follow medical opinion, it is ultimately their decision as to whether the defense should succeed. A notorious example of the jury ignoring medical opinion was present in the trial of Peter Sutcliffe, the Yorkshire Ripper, where the medical opinion was unanimous that the defendant was a paranoid schizophrenic, yet the jury refused to allow him the defense. According to R.V. Byrne, 1960, abnormality of the mental functioning is assessed by reference to what a reasonable man would regard as abnormal. It has a wide meaning and encompasses the inability to exercise willpower and control. It must be caused by a medically recognized condition. Some examples of medical conditions that have been admissible include jealousy, R.V. Miller 1972, even unfounded jealousy, R.V. Vinegar 1979, battered woman syndrome, R.V. Hobson 1997, R.V. Ahluwalia 1993, premenstrual tension, R.V. Smith 1982, R.V. Reynolds 1988, epilepsy, R.V. Campbell 1997, and chronic depression, R.V. Sears and R.V. Gittins 1984. In each case, the defendant must demonstrate that the characteristic was excessive when compared to that experienced by a reasonable person. However, the presence of a medically recognized condition is a necessary, but not always sufficient condition to raise the defense. In R.V. Dowds, the court refused to allow the condition of acute intoxication, binge drinking, despite it being listed as a medical condition by the World Health Organization. 2. The abnormality must provide an explanation for the defendant's act or omission in being party to the killing. This is an issue of causation. Section 1B of the Homicide Act 1957 states that an abnormality of the mental functioning provides an explanation for the defendant's conduct if it causes or is a significant contributory factor in causing the defendant to carry out that conduct. The killing must be caused by the abnormality as opposed to outside factors such as alcohol or drugs, unless the abnormality was as a result of the disease of alcoholism or drug addiction or long-term damage caused by the intake of such intoxicants. In R.V. Tandy, 1989, the defendant was an alcoholic and strangled her 11-year-old daughter. In giving evidence, she stated she had exercised control over her drinking. This proved fatal for her defense, as it was the intoxication rather than the abnormality of the disease of alcoholism which was taken to have caused her to kill. This principle was confirmed in R.V. Wood, 2009, where it was held that giving into a craving could be as a result of alcoholism. The same approach is applied where the defendant is intoxicated by prescription drugs as seen in R.V. O'Connell 1997. Where there exists an abnormality of the mental functioning in addition to intoxicants, the legal position was stated in R.V. Gittins, 1984, and affirmed in R.V. Deichmann, 2003. The jury are required to consider whether, despite the drink, the abnormality of the mental functioning substantially impaired the defendant's responsibility. 3. Which substantially impaired their mental ability. The defendant must show that the abnormality of the mind substantially impaired their mental ability to either 1. Understand the nature of their conduct, or 2. Form a rational judgment, or 3. To exercise self-control. This is a question for the jury to decide after hearing medical evidence. It is not necessary to show a complete loss of control according to R.V. Campbell 1997. However, any evidence of planning on the part of the defendant may be used to show the defendant's mental ability was not impaired as stated in R.V. Sanders, 1991. Substantial means more than trivial and should be significant or considerable according to R.V. Golds, 2016. In summary, the defense of diminished responsibility is a partial defense which can reduce liability for murder to manslaughter. For the defense to succeed, the defendant must be suffering from an abnormality of the mental functioning caused by a medically recognized condition. The abnormality must substantially impair the defendant's ability to understand the nature of their conduct, to form a rational judgment or to exercise self-control and provide an explanation for the killing in the sense that it caused it or was a significant contributory factor. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.